Please be seated. This morning we have 2 cases on the calendar. For this courtroom, we also have cases downstairs going on right now. First case on the calendar, Blue Cross Blue Shield of Florida versus Outpatient Surgery Center of St. Augustine. Counsel, if you're ready to proceed.
May it please the Court, Your Honors. My name is George Merriss of Gray Robinson. With me is my law partner, Alan Windsor of Gray Robinson. We have the pleasure of representing appellants in this case, Blue Cross and Health Options. Your Honors, this is an as-applied challenge to Section 408.7057. Under that statute, as interpreted and as applied by both the First District and the Second District, the non-invoking party to that process is forced to participate and to abide by the result at pain of default and at pain of penalties. That is, in essence, a forced arbitration in violation of access to courts under the Pinnacle case and any number of other cases. It also deprives the right to trial by jury of right to an appeal where there is not an appeal. And
let me ask you about the right to appeal. Why isn't there an option? I know it wasn't raised as an issue in this case, but why isn't there an option for an appellate court to review the merits of the decision that the agency adopts?
I don't know the answer to that other than the fact that the cases have been clear, and I believe it was the Baycare case in the second DCA, if not in the Health Options case, that the only right to appeal relates to the process used and not to the merits. One of the problems we have here, Your Honor, is that there is no record for an appellate court to review other than written submissions. We have a fact finder that's a nameless coding consultant in New York that writes down what he or she determines without fact finding, without cross-examination, without any process. And so, frankly, I believe that the notion is that the agency, because the statute has said, must adopt the recommended order, there really is no review of the process. The legislature somehow intended that to be the case.
Well, I think I definitely read in the second DCA's case that they said the only review is the process. I don't think we said that. In fact, I think we said that whatever 120 discipline is, that kicks in on appellate review. And again, if I understand your argument below, was essentially that you're applying the wrong statute or you're applying the statute wrongly. Why isn't that something under 12068 that we couldn't look at and correct if raised on appeal?
First of all, because a part of effective appellate review is the right to participate in a fact-finding process where we have cross-examination, we have the right to confront witnesses, we have the right to understand and to argue to a real person as to what the facts and the law require. We have none of that here. So as an appellant, as an aggrieved party forced into this process, we could have an appeal where the only thing the court is looking at are papers submitted by one side, papers submitted by another, and a one-page thing saying, we think this PIP statute looks pretty good. No discovery, and nothing whatsoever. So in essence, it would be an appeal without the ability for an appellant to prevail. And the court would be in the position really not of being a reviewing court based on facts processed, but simply, in essence, a decider of the facts in the first instance. We know that this does not provide for a de novo proceeding. If this were a 12057 proceeding, which was followed by an appellate review, that would be one thing. But we know that the legislative history showed that what once was anticipated to be a mediation process then started to convert to an adjudicatory process subject to 120, but then the legislative history makes it clear that that was taken out for the sake of expediency. But the problem with expediency is Expediency is one thing if you have due process and standards. It's quite another for the sake of expediency if you do not have a real adjudicatory process.
But now appellees are arguing that you could have taken this even after the invocation of the dispute resolution process to the circuit court.
Yes, they are arguing that.
Is that correct?
They are arguing that we had the opportunity to opt out.
Right. Is there anything that...
There is no case, there is no rule, there's no letter from the agency, there is nothing in the words of the language, in the words of the rule, or the words of the case law that would suggest that. And in fact, if you look at each one of those in turn, it is absolutely clear. And if you look at the health options case in this court, it is clear that the way this ultimately morphed into law, that the non-invoking party is forced at pain of default, at forced of submission to its regulatory agency and to submission to the legislature to pursue that or to be in default. Now, the reason I say that first, under the language of the statute, if you look at the statute, it makes it very clear that when it is originally submitted, the submitting entity, the voluntary participant, can decide to withdraw the case if they look at the reviewing fee and they decide that the reviewing fee is too much. It explicitly says you have the right to do that. It then says that with the submitting provider, whoever it is, if it doesn't submit the papers, the necessary papers in a given period of time, then there will be a dismissal. And it's just like the rules of civil procedure in a trial court. On the other hand, when it gets to the respondent shall provide materials and shall do it timely, and the only result for not doing that is default. It's not dismissal, it's not opt-out, it's default. If you look in the record, Your Honors, and I would ask the court to look at the record after this, and Appendix B, pages 94 and 107 and 109 and 110 is just an example of the process that's used. And under the rule, what it says is the first thing that happens is the voluntary party, the invoking party, must present a statement, and that statement must be, we have these disputes, we're asking you to resolve it. And as a part of that, it has to check the boxes of any exceptions. Is this a matter of interest? Is this related solely to an issue of prompt payment? No, no, no. One of those is this claim is not the basis for an action pending in state or federal court, which the appellees also suggest that we can make something pending later on. No. What the rules say then is within 10 days thereafter, the Maximus shall decide whether or not there's sufficient information to accept the claim. And once this is done, they send out a letter under a rule, and it's in this record that says, upon initial review, we see that this is appropriate in our jurisdiction and we accept it for review. Then there's instructions to the respondent. This has been accepted for review, and here's what you have to do. You have to file this. You have to do this. And if you do not, there is default.
Let's go back to the statute. The statute seems to say that Maximus won't review claims if there's a suit pending in state or federal court. And the position taken by the appellees is that the respondent could file a deck action at any time, and that gives both parties all the due process requirements that they want. Are you saying that just is simply wrong, that the respondent does not have the right to file a lawsuit?
Once this is pending, once this has been filed, and once it's been accepted for review, when Maximus says there is no action pending in suit, there is no opportunity to make something pending that wasn't pending before.
Just about every district now has dealt with this statute, and they keep talking, everybody says this is a voluntary process.
I'm sorry, for
It's a voluntary process, which means it's got to be voluntary for both the petitioner and the respondent. And I know that this issue hasn't come up yet where a respondent has attempted to file a lawsuit after this procedure has been invoked. But, you know, again, what this court has to do in statutory construction, statutory interpretation, is to look for an interpretation that makes the statute constitutional. What is a reasonable rule of that statute to say that the respondent could file a deck action even after this procedure has been invoked?
No, Your Honor, I do not believe so. The court certainly must reasonably construe a statute, if it can, to render it constitutional. What the court cannot do, I respectfully suggest, is to rewrite the statute and to disregard, again, a decision from this court about what the statute means, and to be able to construe the statute, it has to be consistent with the obvious legislative intent. It can't now create a new statute. What we have here is a situation where, first of all, in my view, the English language is pretty clear. Pending, means in existence. Under the rules, under the statute, under the process used here, that decision is made upon the moment this process is invoked, when they say there is not an action pending.
There is an action pending at the time that a claim is filed with Maximus. And a week after that claim is filed, the plaintiff that filed that lawsuit voluntarily dismisses it. That case was pending at the time the claim was filed. Does that mean Maximus cannot review that because it was pending at the time the claim was filed?
If it was voluntarily dismissed, it would be accepted for review. If it were voluntarily dismissed by the invoking party, then, in theory, at that point, the voluntary party, understand, can withdraw under the health options case, can stop the case up to the time that the facts are submitted. Just like in a trial court, you can voluntarily dismiss your suit. So that's what the health option says. The voluntary party can do that. But if, in fact, they continue to pursue it, the only right the non-invoking party has, and again, it's in the forms and in the record, is to contest eligibility. And by that, does this fit within any of the exceptions? So if the opposing party comes in and says, there was a suit pending in court relating to this, then Maximus can look at that to determine whether it was initially accepted properly. There is nothing to suggest that you can take a process which supposedly was intended to have a decision, just like health options said, and then turn it into a moot court exercise, as the case said, by virtue of later you're creating a case. You're not talking about a pending case. The analogy that this court used to make sense of this, again, on the other side, when you have an invoking party, is just like a trial court. You file a complaint, you can dismiss your complaint. You can voluntarily dismiss your complaint until it goes to a jury or it goes before a fact-finding judge. The defendant cannot voluntarily or involuntarily dismiss your case. They are bound by that. This court could have said that this was truly voluntary with respect to the invoking party. It did not do so. It said to the contrary, that when you look at everything and when you look at the legislative history, it makes it clear it was intended to be a process with finality subject to the common sense way you do something. There is nothing here, I would suggest, especially in the words or in the rules or in the practice, that says that we can create a lawsuit to get out of this. I would suggest that if there was anything in case law or ACCA's rules or letters or anything else that suggested this had been done in the past, they would be all over that and they would have presented that to the court. And just as a matter of common sense and policy, If you have a process that's supposed to be expeditious and in the greater scheme of things, make sense and to be less costly, how could it be that one could read in an opportunity basically at any time to undo the process by filing a deck action in the first instance?
In the alternative, though, if we agree with you and hold the statute unconstitutional, the process goes away altogether.
Not necessarily. Not necessarily. One can decide voluntarily to take their chances, and to just like an arbitration, have an arbitration that is truly a voluntary arbitration, not a forced arbitration.
I'm glad you went there, because that was my next question. Isn't that what we have in this case? Isn't this a case where the record doesn't include any sort of reservation of rights or objections to the process? I mean, I know you cited in your brief a quote where you objected to the methodology you expected them to use, but I couldn't find anything where your client said, we don't want to go through this process. Let us out. Interpret your rules as you're going to interpret them on appeal, and let us out.
The objection was at the point of having to pay part of the claims process, saying this reserves all right to appeal. The reason for that, Your Honor, is that under the case law, I would suggest it's very clear that when it comes to a constitutional challenge to a process, one does not have the need to object to an unconstitutional process, because that proceeding and the entities there cannot deal with the constitutional question.
Well, how do you square that comment? How do you square that with your comment that your response to my initial question was, no, the process doesn't go away because we can choose to go through it? I mean, I guess I'm having trouble understanding how the record we have before us doesn't reflect a party who chose to go through this process, got an adverse result, and now is trying to undo the process that it voluntarily went through.
We don't have the opportunity to get out in the process short of appealing. If we don't go through the process, we get defaulted, and we get reported to the legislature. We could go through the process and accept the result and be done with it.
Well, you could have filed a writ of prohibition, I guess, with this court, couldn't you?
And I believe that would have been summarily dismissed by virtue of the fact that you have to go through the administrative process before and then bring a 12068 challenge to the constitutionality of the process. Just as if we had brought a civil court action, a DAC action, the cases there say the circuit court should not get involved, the Key Haven and all the other cases, unless and until it's through the process, and then in the 12068 appeal, then that can be decided. That's precisely what we did. Looks like I'm about out of town. I'd like to reserve the rest for the
May it please the Court. My name is Jerry Rumpf. I represent Lake Sumter EMS and Bayfront Medical Center. At the table with me is Tracy Cooper. She represents the Agency for Healthcare Administration. I will present for 16 minutes, and we reserve 4 minutes of our time for Augu. The Court should deny the HMOs the relief that they request because, first of all, they have waived their constitutional rights by creating the position that they're in and then participating in the dispute resolution process. Furthermore, they have been before 4 Florida DCAs trumpeting the constitutionality of the statute, maintaining that it's voluntary, and advocating that the courts in ACCA respect its provisions. Today, they challenge the constitutionality of the statute.
Well, in there, you'd have to admit, wouldn't you, that there's a significant difference from defending the statute's constitutionality where a party chooses that forum, I mean affirmatively chooses that forum, as your clients did, or the providers at least did in those other cases, whereas here you have somebody who is, in their words, drug into the process against their will. You'd have to at least concede there's a distinction between the prior cases and this case, wouldn't you?
the way that the statute reads, Your Honor, I think the distinction is slight. The statute says that the party who wishes to submit its claim to the dispute resolution process may do so and invoke the statute. But it also says that if that claim is subject to a pending state or federal court action, that the dispute resolution organization cannot review that claim. If you couple that reading with this court's holding in Health Options versus Augu, which said that the dispute resolution process isn't final until fact-finding is complete, then I would say that the invoking party could file the claim. The responding party then has a right to stop it with a judicial proceeding in state or federal court and say that they're not there voluntarily. But that's not what happened in this case. It's telling that the HMOs don't buy what they're trying to sell this court, and that this is an arbitration process. Because if they did, they could have brought an action under the Florida Arbitration Code, Chapter 682, and either stayed the proceedings if they didn't feel that they had the right to be there, or even afterward, they could have brought one under 682.13 and asked the court to vacate the arbitration award, saying that they didn't, that they weren't in arbitration voluntarily and they shouldn't be subjected to it. They didn't do that. Instead, they came here and they asked this court to overturn the statute as unconstitutional. To find a state statute unconstitutional, the HMOs are burdened with proving to this court beyond all reasonable doubt that the statute is unconstitutional. This statute is validly enacted, so it's presumed constitutional. It's been ruled constitutional. And the cases say it's voluntary, which the HMOs, by their own admission, say that if it's voluntary to everybody, then it's constitutional.
Well, what's the point of this process if someone who's brought into it doesn't want to be there, can simply go out and file a lawsuit and get out of it? I mean, what purpose does this serve anymore?
Well, I think that that's how the statute respects the party's constitutional rights, is allow them beforehand to get out of that if they don't want to be there. But once they voluntarily respond, ask for extensions which are permitted, respond, submit paperwork and argument, and ask the dispute resolution organization, hey, please rule in our favor, well then it's finalized. And it's finalized, Your Honor, because the legislature recognized that these emergency medical service providers are mandated by statute to save lives first, inquire about payment later, which is what happened in this case. The emergency service providers complied with their statutory mandate.
But you can't be arguing to us, can you, that there is no review in any court at any level of the merits of this decision? I mean, that can't be your position.
My position is, and what was held in Baycare, Your Honor, that the dispute resolution process is subject to judicial review under 120.68, which, granted, doesn't allow review of the merits of what happened. It allows review.
I mean, other than the second DCA saying that, how can you read 120.68 and all the various things that we can review to not allow us to correct erroneous, and if raised, and I know it wasn't raised in this case, erroneous legal conclusions, facts that have no basis in the record? I mean, that's what 120.68.7 lists. I mean, that can't be right, can it?
Well, Your Honor, I think that if you look at the legislative intent surrounding the statute, and again, that they preserve the constitutional rights for everyone before the fact-finding is complete, that there needs to be inexpensive, efficient, costly resolution to these matters to lower health care costs, protect state interests in that area, and to assure that these emergency medical service providers have a way of knowing that they're going in to provide these costly services to somebody, that they're going to get paid on the back end, even if they're not contracted with this individual's payer.
So it's got to be mandatory then?
I would say it does, Your Honor, yes. I think that there does need to be some finality to the process.
Okay.
And so, if this court, in interpreting the statute, can assign two reasonable interpretations to the statute, one that renders it unconstitutional and one that renders it constitutional, then the court must assign it the reading that renders it constitutional. And the reading of the statute, 408-7057, and the case precedent of health options, as I said before, and then coupled also with this court's case precedent in Aetna versus 21st Century Oncology that says even after fact-finding is complete, a final order is entered, and the parties settle after the fact, and they want ACA to vacate the award, they can do that. And so if the court can read the statute to say that the parties can settle even after the fact, then the court should at least find that the responding party can bring a judicial action and stop the process and say that they're not required to be there.
Well, what meaning do you give to the term pending there? The appellants take the position that if there's a suit pending at the time the claim is filed with Maximus, then Maximus can't review it. What reading do you give to the term pending there?
Well, Your Honor, I would say that certainly if an action is pending before the invoking party goes to the dispute resolution organization, then it's pending, it's ongoing. But even after that party goes to the dispute resolution, and the HMOs just said that they can challenge whether or not the claim satisfies the requirements for the dispute resolution organization to review the claim, then they could go, as soon as they get notice from the dispute resolution organization, they can say, wait a minute, we don't want to be there, let's go to the state court. And the Florida Rules of Civil Procedure say that an action is commenced when it's filed with the court. Well, then, as soon as it's filed, it is pending, but fact-finding hasn't been completed in the dispute resolution process, so they could then challenge, to the dispute resolution process and say, we're not allowed to be there.
Well, the rule doesn't seem to say that. I know in your appendix you attached the rule there, and basically it states, once the resolution organization determines that the application meets statutory and rule criteria, it must review the documentation submitted, and the process gets going. Which, if you read that rule, it doesn't provide for filing suit after the claim is submitted, or does it? I don't see anywhere where it does.
Well, first of all, the statute supersedes the rule. If there's any conflict between...
The statute seems to be consistent with the rule. I mean, the statute talks about, once that claim is filed, then there's time limits for supporting documentation to be presented by the petitioner and the respondent, and the train really gets going at that point, and it doesn't talk about a procedure to take the train and slow it down after that. I don't see that in the statute or the rule anywhere.
Your Honor, the train does get going once the process is invoked. However, like I said, if you couple case precedent with the reading of the statute and what the courts have said before, and by the way, these are cases that the HMOs have helped this court shape the jurisprudence in this area, and they say that fact-finding that the process isn't complete until fact-finding is complete, then I think that the process, it's not solidified, it hasn't gelled, and it hasn't stopped anything from coming along and stopping it. Just as, again, an arbitration, which the HMOs claim that this is an arbitration, 68203 of the Florida statute says that if a party is being compelled to arbitrate against its will, it could go to a court of competent jurisdiction and ask that court to stay those proceedings. But that's not what happened here. And so they have that same remedy available to them.
What is your view? It seems to me your best argument in this case is that they have acquiesced to this process by proceeding through it willingly, quote unquote, without raising any sort of objections, yet they cite a portion of their response to the Maximus group where they did raise an objection. Why wasn't that enough to at least put everyone on notice that they were not acquiescing to this process?
Well, Your Honor, their objection or their statement to the dispute resolution organization at most was precatory. It's like, well, we really don't, we really hope that you take this methodology and whatever. But they didn't go anywhere else and try to stop it. And they don't have, the non-invoking party can't withdraw the invoking party's claim. We concede that, okay? But they could take a number of actions, even if they didn't file the state court action. First of all, they didn't even pay the emergency service providers what they had paid them in the past. Traditionally, they gave them a payment and then they sent them a letter and said, that's all you're going to get. And oh, let us remind you, you can't go to our members and seek additional reimbursement from them pursuant to Florida law. So they could have paid them the proper amount. They could have continued conversation.
Well, they argue, well, you know, of course, at any point we can concede and say, yep, you're right, we're going to pay you. I mean, but what in your mind would they have had to have done in the dispute resolution process to say, to dig their heels in and say, this process is not constitutional? I mean, is it appropriate for them to do it the way they did and raise it for the first time on appeal, or was there something more they had to do?
No, Your Honor, it's not appropriate for them to do it as they did it here for the first time on appeal, because they went through the entire process and they fully participated, and then they come to the court saying, oh, we shouldn't have been subjected to this because the statute is unconstitutional. Florida law has held that a party can waive their constitutional rights through conduct that warrants an inference that they've relinquished those rights. Even an attorney can waive their client's constitutional rights for tactical reasons. And so they did all of this knowing, or at least they say that, they never wanted to be there. Okay, well, if they never wanted to be there, they should have either gone to a court and said we shouldn't be here before the process was ever completed, and probably would have stopped that process if you accept the provider's arguments, and then, or they could have even gone to the agency. They could have gone to the other side and said, will you please withdraw your claim? We want to continue to negotiate, or we don't want the current contracted dispute resolution organization to determine this. Let's go to another arbitrator or mediator and try to settle this through some other third-party neutral. But none of that ever happened. They went through this process. They never tried to stop it. They got a determination with which they were unhappy, and we're here today. And finally, I'd like to conclude that the HMOs, they're sophisticated, aware, informed. They were never affirmatively misled about the statute's parameters. They knew it existed. They knew the providers could go out and invoke it if they didn't pay them the amount that the providers were seeking. And they allowed that to happen. The HMOs have helped these courts develop the current jurisprudence as it stands. Baycare Health Systems held that the statute was constitutional. Adventist Health and Merkel informed these HMOs that they could file a declaratory judgment action, that is a proper way to determine reimbursement under 641-513.
Your representation of this court is that those prior cases that dealt with providers' challenges, some of them dealing with provider challenges in circuit court, your representation of this court is that those cases held or included statements clearly informing the non-invoking party of an alternate way of going about things.
Yes, Your Honor. In both Adventist Health System and Merkel, the HMOs challenged the ability of the providers to bring a declaratory judgment action to determine proper reimbursement under 641-513.
And the courts held that a declaratory judgment action by a provider was an appropriate course of action.
Yes, Your Honor, it did.
But you're suggesting that those cases also held or included statements to the effect that a HMO could bring a declaratory judgment action to get out of this process.
Well, I think that, again, no, it didn't say that, Your Honor, but what it did say is that a declaratory judgment action is proper, and the declaratory judgment statute says that a party can bring a judgment action to determine its rights under a statute, and so it was available to the parties here. They could have brought a declaratory judgment action to see if they were compelled to be in the dispute resolution process under 408-7057. I see I'm getting close to my time that Augu is going to come here to present, so I just reiterate that they created the position that they're in, so the HMOs have waived their constitutional rights by voluntarily participating in this process. They have taken contrary positions before 4 Florida DCAs, and they have failed to prove beyond all reasonable doubt that the statute is unconstitutional. For all points that I haven't discussed, we rely on our briefs. Thank you. Augu will present now.
May it please the Court, my name is Tracy Cooper and I represent the agency. We believe that this process is subject to 120, that objections could have been made, the appellant could have opted out at any time.
Ms. Cooper, let me ask you about that, because I know in your brief you made a strong point of the fact that the appellants could have opted out at any time, and you said they could have done that with a letter or a phone call. Where is that in the rule of the statute that would have given the appellants the right to have opted out with a letter or a phone call? It looked like to me they would have been subject real quick to that default provision if they did that.
Your Honor, I don't think so for two reasons. One, it doesn't say in the default statute that it's only failure to provide the information in a timely basis that causes the default. It's not asking to opt out.
But if they had called you and said, we want to opt out, and didn't provide their documentation on a timely basis, you think they could have confidently, under that statute or rule, have considered themselves not to be in danger of a default?
Probably not under the rule, but I will tell you the opposite way, which is what they chose to do, gave them no option to opt out. They then, by consenting, by providing the information, they consented.
But they're saying they didn't have any choice, though.
They're saying that they didn't have any choice, but it's very obvious that there are reasons that you can get out of this that are not actually in the statute or in the rule, such as settling, such as going to the other party and coming up with another way of resolving your disputes. And Augu's not going to force somebody to be there if you don't want to be. If you want to go to circuit court, go for it.
Well, follow that through to the logical end. What if they just come in and say, we think we've paid them all they are entitled to. Mm-hmm. We consider this to be a voluntary process because we somehow glean that from these cases as to HMOs. Therefore, thanks for the invitation, but we're opting out.
Okay.
Period.
Then the initiating party can file in circuit court.
So they're
in no worse shape than they would have been.
So what's the point of this process then?
The point of this process is if you look at the fees that are involved in it, nobody paid more than $600 to resolve these disputes. That's much cheaper than a circuit solution. The parties want to do this quickly. Most of these cases took 3 months.
I guess the HMO, I doubt that they're sitting around their offices wherever they are saying, I hope I get sued today, so I only have to pay $60 rather than filing the circuit court. But if what you're telling us now, which I don't think, at least maybe I didn't read your brief close enough, that they can opt out simply by saying, we don't want to be here, and make the other party go file in circuit court, rather than saying we can only opt out if we go file in circuit court. That's a big difference. I think that's a material difference, but it's not one that's really apparent to me from the statute.
It's not apparent from the statute. I'm just saying as a practical matter, they didn't even try it. So they can't say that they wouldn't have been let out. I mean, honestly, their whole arguments are based on things that they never tried to do. They never filed an objection. They never asked to get out of the procedure. If they'd done either of these things and they hadn't been allowed out, or their objections hadn't been addressed, then they would have had a much stronger claim. But here, they did none of those things. They didn't preserve their right to raise these constitutional issues because they didn't object. And they certainly didn't preserve their rights to raise the merits.
Maybe just for information purposes, I know it's not part of our record, how many of these cases are going on out there on an annual basis, if you know?
I don't know right off the top of my head, but there's thousands. We get lots of them. Blue Cross is one of the more common HMOs to be involved, but it's just because they're so big.
And how many opt to go to circuit court?
I don't know, Your Honor.
Any? Have any?
Your Honor, I don't know. If they file in circuit court, then that takes it out of... Maximus doesn't even send us the information at that point. Thank you.
Thank you.
May it please the Court, I don't have much time, and I will be brief. state is right about one thing. There are thousands of these cases. And based on their argument, there would be thousands of writs of prohibition, thousands of deck actions required to get out of this process.
Well, based upon their argument, it sounds like all you have to do is write them a letter saying, thank you, we have no interest in participating in this process, and we will await the service of a complaint from circuit court, doesn't it?
And a couple things about that. Number one, if that were to occur, not these providers, but other providers would file a writ of prohibition in the circuit court, or a writ of mandamus to the agency, and to Maximus saying, are you kidding? No, absolutely not, you can't do that. So now, what supposedly is a simple process is back to a fight where there's not a word in the rule, there's not a word in the statute, or a word in the process itself that suggests that's the appropriate remedy. And I would, again, urge Your Honors to look at Appendix B, page 110, which is the directions to the respondent in this as to what you can do and not do. And as we know in the administrative process, those participating in the administrative process have the right to a clear description from the agency as to what your rights and obligations are. There is not a word in here to even suggest that you can get out of a process like this. Now, Your Honor, going to this issue as to, we await an action in state court. If that were to be the case, then what a great way to change the fundamental elements of the rule of law by forcing someone who doesn't believe there's a dispute, who believes that they have paid fully, where we have to go into circuit court and we have the burden of proof to show that we don't owe the money.
Right. I agree with you. That's silly. But what they have told us today, and again, unless I misread it in the brief, the first time I've heard it, that you don't have to file. All you have to do is say, we don't want to be a part of this process.
And we have the agency that governs our conduct. We have the legislature.
I'd get a tape of this proceeding is what I'd get.
And we have all of that requires that the legislature has mandated this agency to put us into default. Now, just because the agency is now avoiding the terms of the statute doesn't mean it's not going to come back to us when the legislature says, do what this court has said you must do what the Second District Court has said you must do, and you don't have the ability to save the statute by not following it. For all of those reasons, I would urge the court to find the statute unconstitutional as applied. Thank you for your time.
Thank you, counsel. Thank you all.